Good afternoon, everybody. I wanted to talk a little bit about the liability for wrongful takedown, wrongful blocking and so on. I call it a forgotten liability because it's been, well, it was largely forgotten, I think, even today. We've had very little mention of it over the last 2 days. And it's the possible liability of the individuals behind a wrongful takedown, behind wrongful blocking. What happens where, through carelessness or deliberate plan, there is an attempt to take down non-infringing content? What redress is available to the individual whose content is taken away? The slide you have in front of you, the evolution of remix culture, was a classic example of fair use, which unsurprisingly found itself blocked on YouTube by automated processes used by content holders. The problem here is that intermediaries have a very strong incentive to give in to complaints, irrespective of the merits of the complaints. And that's so even in those situations where the intermediaries enjoy some form of immunity. Christian Allert and Chris Marsden did a great study in 2004 where they took down a fake web page, or rather a web page containing a copy of John Stuart Mill's Passing on Liberty on the basis of fake complaints. They created a fake society which would write to ISPs saying, we own the copyright in this work, somebody has hosted it here without our permission, how dare they, please take it down immediately. And instead of saying, no, this is a classic work from a period as a result of which it's well out of copyright, the ISPs almost invariably either took it down immediately or in some cases volunteered the details of the people behind the account to the complainants without any legal basis for doing so. And of course we see this mostly in the IP context, but we also see it particularly in Ireland in the area of defamation, very recently contempt of court. There's a concern that the right to be forgotten, if it is extended further, may end up with intermediaries forgetting or deleting, simply because it's easier and cheaper without giving adequate weight to the public interest factors identified by the ECJ. So the overall question I want to ask is, well, what remedies are available in this case? And by remedies, I don't just mean the ability to reinstate content. That is not a remedy as such. That is not a form of compensation for a harm that has been suffered in the intervening period. What remedies for any damages, or what sort of injunctive relief against future complaints might be available? Well, we have two classes of complainant, and we have to differentiate how we deal with them. We have the careless and the clumsy on the one hand, and we have the censors on the other hand. And before I go any further, I should really ask how much time I have so I can determine.
You have 7 minutes.
7 minutes. The careless and the clumsy are mostly the people using automated algorithms. We have the music industry to a certain extent, the movie industry to a certain extent, and we have very recent research from the fantastic takedownproject.org who identify over 30% of requests from a random sample they took from the Google submissions to chillingeffects.org. Over 30% of the automated notices were problematic, with a full 60,000 automated notices coming from professional media monitoring companies that targeted sites that have been dead for over 18 months, sites that have not existed for over 18 months. There's a substantial scale there, but the scale is just as much a problem at the level of the individual censors. There are a lot of individuals who seek still to abuse copyright law for particular purposes. Scientology has been known for this in the United Kingdom ever since the case of Hubbard and Vosper, which long predated the internet, but raised exactly the same concerns about use of excerpts from Scientology works in a book critical of Scientology. And while these are anecdotal examples, they are, in my experience, representative of a much wider set of abuses. The EFF's takedown hall of shame is particularly useful here, and again, unsurprisingly, the Church of Scientology crops up again and again as a particularly aggressive user of copyright and trademarks in an attempt to shut down critical websites. What remedies do we have? We have almost no remedies against intermediaries in these cases. Terms of use tend to exclude what remedies we might otherwise have, and very often it's not clear what remedy might be available in some cases. I mentioned defamation as an example. I might be saying to my video was taken down and wrongfully branded a copyright infringer. But these claims, practically speaking, are going to be very hard to bring home. Do we have remedies against the censors and the clumsy? Well, we have all the problems with the underlying causes of action. We might, for example, be able to bring a defamation action, but that would be very difficult to do. We might, in some cases, be able to bring an action in those jurisdictions where there are civil causes of action for wrongful assertion of trademark rights. But again, that's actually very difficult to do indeed, even in what might seem relatively clear-cut cases. The United States addresses this by introducing Section 512F of the Digital Millennium Copyright Act, which creates a remedy for knowing misrepresentations. Unfortunately, to a large extent, it hasn't worked, and despite some excitement earlier this week about a case that forced me to rewrite these slides, it probably still doesn't work. Section 512F was gutted a number of years ago by a case called Rossi. And in the Rossi case, the court held, in effect, that subjective bad faith was required before a service provider could be liable. Before the person making the complaint to the service provider could be liable. There was no requirement for any reasonable investigation on their part before they issued the complaint. And that was seen by many as killing it off. A decision earlier this week in the Dancing Baby case arguably resurrected it. Now, I hope I can play this, even if I am short on time. So, more baby or more me? Well, I'd go to baby personally.
More baby.
Cute baby, dancing. Who doesn't like that? You might not have been able to make out that that was Prince playing in the background. I certainly didn't the first time I heard it. But those lovely people at Universal Music did. And they took it down. Boom. And they took it down. And Miss Lenz brought an action against them, saying that this had been done improperly. She said in particular, look, this was clear fair use. You should have considered fair use before issuing the takedown notice. You didn't. Therefore, your notice was misrepresenting. And the Ninth Circuit ultimately agreed with her and also agreed that she didn't have to show any substantial monetary damages. But does that really help us? Does Section 512F become effective as a result? It doesn't really. We still need subjective bad faith. If they have a good faith belief that there's no fair use defence, however boneheaded and ignorant it might be, then there is no liability. Likewise, the court actually goes out of its way to stress that the implementation of computer algorithms appears to be a valid and good faith middle ground for carrying out a fair use assessment, which I think is a very difficult claim to make in an area that is so nuanced, but again leaves the leeway very much with those making the complaint. And in any event, this is a decision that's coming far too late in the day because the DMCA itself is largely no longer relevant. We've moved on to what the American lawyers are calling the DMCA Plus, or the para-DMCA. Those systems which involve direct contractual relationships between sites such as YouTube and content owners, bypassing entirely the existing DMCA systems. As a result, Section 512 simply won't apply because there won't be a DMCA notice to begin with. There will be no statutory cause of action in respect of an abusive takedown notice under these private arrangements. Why is it relevant for Europe? Well, we've already heard mention of the existing consultation, as very recently leaked. I'm not sure if that answers a couple of the questions I had in relation to this slide. In particular, the 2012 Commission consultation on notice and action accepted that there was a need for specific means to address abusive notices and abusive actions against legal content. And I'm not sure whether the current consultation and the current process adopts the same approach or whether it's abandoned that.
You want me to answer? No, the current consultation takes already into account the responses from the last one. And we know what the respondents told us about it, and we have certainly idea.
Okay, well hopefully then there is still a recognition at European level that there is a need for this, and that is something that remains on the table. I wasn't heartened when I read the consultation, the leaked version of the consultation document, which also forced me to rewrite these slides a couple of days ago, because it did seem to suggest a greater degree of hostility towards immunities in general, and the use of greater obligations in respect of these platforms as they are now being defined. But more generally, just to step back from this a little bit, this is an area of fundamental rights concern. There isn't a right under Article 10 of the ECHR to freedom of expression. It's a right that is often exercised through intermediaries. It's a right the court has accepted on numerous occasions, starting with publishers, moving to radio and television, and now the internet. It is a right that extends to the right to use the intermediary to reach the wider audience. And to the extent that we are allowing legal obligations to chill the exercise of that right, to take down content that may not be infringing on the basis of uncertainty on the part of the intermediary, then I think we are trenching on that right, and an argument arises that there is a positive obligation on the state to take a positive act to protect that right, if only by ensuring greater clarity for the rights holder, greater clarity for the intermediary as to the duty that they owe the rights holder, and in particular, and remedy, as required, let's not forget, by the ECHR again, we must have an Article 13 effective remedy against the individual who is responsible for this Article 10 right being interfered with. And for the time being, at least, I suggest we're not really doing enough to protect that right.